Hello, everyone, and welcome to today's citizens training on Georgia's open government laws, the Open Records Act, and the Open Meetings Act. Today's training is brought to you by the First Amendment Clinic at the University of Georgia School of Law and the Georgia First Amendment Foundation. My name is Samantha Hamilton, and I am Senior Legal Fellow with the UGA First Amendment Clinic. A big thank you to the Georgia First Amendment Foundation sponsors, seen here on the screen, without whom today's training could not be possible. Today's presenters will be three law students who work with the UGA First Amendment Clinic. In order, they are Kyle Renner, Paige Medley, and Austin Albertson. They'll be addressing questions collected by the Georgia First Amendment Foundation that you and other members of the public have submitted about open government in Georgia. We'll have time at the end for you to ask other questions that aren't covered in today's presentation, so feel free to write your questions in the Q&A box below. And without further ado, I'll pass it off to Kyle to get us started today. Thanks to everyone for being here.
Good afternoon. I'm Kyle Renner, and I'll be starting this presentation by talking about the Open Records Act. The Open Records Act, or the ORA, is Georgia's sunshine law that sheds light on many of the records kept by the state and local governments, as well as its agencies. However, it does not apply to federal entities. Georgia's public policy stands in strong support of making records available to the public for inspection and review. This helps maintain confidence in the government, as well as instill integrity in our system by encouraging good behavior from the state, as well as its many agencies. The ORA applies to a large variety of entities directly run by state and local governments, or those receiving substantial funding from the government. Thus, the term agency includes all subdivisions of local, county, and state governments, as well as nonprofits receiving more than 1/3 of their funds from an agency. Some examples of agencies include the departments run by the state, like the Georgia Department of Labor or the Georgia Department of Corrections, as well as smaller entities like a city's budget office, local police and fire departments, the Human Resources Office for your city and county, your county's zoning board, and the school board district for your school district. The public is able to submit records requests, preferably in writing, to the custodian of that entity's records. Members of the public are not required to state why they want to review particular records, but written requests are encouraged because they provide the benefit of clarity and identification. Agencies have to respond to requests in 3 days and either produce the records it has available or provide a description of the records and a timeline for when they will be available, which should be as soon as practicable. While this language seems to give agencies the leeway to ignore requests they may want to deal with, it's important to bear in mind that refusing access to records, failing to provide documents in the required time, or intentionally making documents hard to review can open people working for an agency up to civil or criminal penalties. Nevertheless, while the ORA favors openness, it also contains a list of numerous exemptions on disclosure to protect certain information. Many exemptions typically relate to privacy interests for government employees and private citizens whose information is stored by the government, as well as security interests for the state and law enforcement. The ORA contains some other key exemptions that are frequently invoked by agencies. Some of these exempt records that are predictable, like medical records, motor vehicle accident records, trade secrets, records containing communications subject to attorney-client privilege, or records that would compromise security against criminal or terrorist acts. Other exemptions may be very specific and highly tailored, though, like exemptions on personnel records of public employees, like confidential evaluations for hiring or firing, records identifying persons who applied for or were considered for agency executive head positions, except for 3 finalists to be voted on, records that reveal information collected or received by counties or cities in connection with neighborhood watch programs or burglar alarm systems, records required by an agency for setting up carpooling or ride-sharing programs, and probate court records related to weapons carry licenses, as well as many more. Some agencies may try to use seemingly broad exemptions, like trade secrets or attorney-client privilege, to resist disclosure of records that should be available to the public. It should be noted that exemptions are meant to be applied narrowly, however, and the rest of a record can be released without the exempt portion to ensure that the public maintains their access. The first of many questions that you may have is what records are actually public? The ORA defines public records very broadly. A public record means any record prepared, maintained, or received by an agency or a private person or entity doing work for an agency. The definition of public records allows people to access a broad spectrum of materials, including, but not limited to, documents, papers, maps, books, tapes, photos, computer-based information, emails, data, and similar material. This means that a lot of records in many different forms are open to the public. Another frequent question is whether police videos are publicly accessible. Police videos are accessible once the case related to the footage is closed. For closed cases, police car and body camera footage can be requested from law enforcement. For open cases, however, the situation is less clear. Georgia courts have not conclusively determined that recordings related to pending investigations or cases must be produced. However, it does not hurt to still make requests for them. Whether police video related to an open case is produced will depend on the discretion of the law enforcement agency that holds the video, as well as the sensitivity of that case's subject matter. Nevertheless, videos from closed police cases should be open to the public. Another common concern is whether school records are open to the public. The Family Educational Rights and Privacy Act, or FERPA, is a federal law designed to give parents of minor children and students over 18 control over the access to education, academic, and financial aid records. These parties can consent to disclosures of that information, but educational institutions risk loss of federal school funding if they disclose without consent. However, it's worth noting that no school or other educational institution has ever lost funding due to FERPA-related disclosures. This is important as many educational institutions may try to deny otherwise valid records requests by hiding behind FERPA. Though student-specific information is covered by FERPA's consent measures, other types of school records that aren't specific to particular students are obtainable under the ORA. These include school policies, curriculum documents, vendor contracts, and more, which generally remain open to the public, as seen in our next slide. So people still have access to many records related to schools, though not necessarily those records pertaining to student performance. Finally, many people have asked within the last year and a half if their local school board must share data used to formulate COVID-19 policies. The answer is a qualified yes. If the data was created, maintained by, or received by the board, that data is considered a public record that is subject to disclosure under the ORA's broad public record definition. Certain exemptions might apply to data to limit some public access, such as limits on releasing personally identifiable information in the ORA, and under privacy laws like FERPA, as well as the Health Insurance Portability and Accountability Act, popularly known as HIPAA. These exemptions should be narrowly construed, though, to allow access to other non-exempt portions of data. It's also important to note that because it is popularly misunderstood, HIPAA's protections on individually identifiable health information only prohibit disclosure from health plans, healthcare clearinghouses, and healthcare providers like doctors, physicians, or pharmacists who transmit health information in electronic form for certain transactions. This covers a narrow group of entities. Entities not covered under HIPAA may disclose health information so long as it's not individually identifying. As mentioned above, other exemptions may still apply to limit disclosures, such as the ORA exemption for medical records. When people request data, agencies are required to produce stored data by carrying out common commands to tailor it, such as by filtering the data by certain parameters or applying ranges to a data set to narrow it down. However, agencies are not required to recompile data in a new way that differs from the form it is kept in to fulfill a data request. In response to data requests, agencies are also not required to create new data. For example, several agencies used to publicize daily COVID numbers, and our clinic has actually been working to access some of that data, but this can be hard if the agency itself has completely stopped keeping track of daily COVID numbers altogether and no longer has that data available. And now, having discussed some finer points of the ORA, I would like to pass this presentation off to my colleague, Paige Medley, who will be discussing Georgia's other sunshine law, the Open Meetings Act. Thank you.
Hi, I'm Paige Medley. I'm a third-year law student here at UGA working in the First Amendment Clinic. So now that Kyle's covered some of the basics of the ORA, I'll be focusing on Georgia's Open Meetings Act, or the OMA. So similar to the ORA, the OMA is focused on the concept of government transparency. This idea that government functions best when the public is allowed to participate, or at least observe, their government officials in action, making decisions that are going to impact the public. So the OMA has three key requirements. The first being that agencies provide citizens with contemporaneous access to government meetings to allow citizens to observe and monitor their elected officials and others working on their behalf. The second is that government bodies provide reasonable notice of all meetings. And the third is that government bodies publicly post summaries and minutes of their meetings. Like the ORA, the OMA applies to all agencies, and this definition of agencies is the same as already discussed in the ORA. Entities who must transact their business in the open are, for example, anything from meetings of city councils, county commissions, regional development authorities, to library boards, school boards, hospital authorities established by state or local governments, planning commissions, zoning boards, even things like nonprofit corporations operating public hospitals, and most committees of the University System of Georgia. So you get it. Basically, any agency functioning as a decision-making body of the government is required to allow public attendance in these decision-making processes. So a frequently asked question we received was whether local governments are required to allow public comment during meetings. The short answer is no, they don't. The OMA has no requirement that public comment and only requires access to the meeting, not a right to participate. However, many jurisdictions allow for public comment at certain open meetings, like city council or school board meetings, and have for long periods of time. For example, in Beaufort, Georgia, the chairman of the local commission has invited public comment at the end of meetings for more than 20 years now. Allowing for public comment is consistent with the spirit of citizen participation in democratic government. And some may say it's bad politics not to allow for public comment. However, the OMA does not require it. It's also important to note that once the government allows for public comment at meetings, it cannot close down this public comment period simply because the government officials at the meeting don't like what members of the public have to say. Closing down public comment to silence expression of a particular viewpoint runs afoul of the First Amendment. That's because the First Amendment almost always prohibits the government from regulating a private person's speech based on the speaker's perspective or point of view. So basically, no, there's no requirement for public comment, but many places do. And once it's open, the government can't shut it down arbitrarily. What's an executive session and when can it be used? An executive session is a meeting lawfully closed to the public. The purpose behind executive sessions is to protect confidential information and to foster robust discourse between government officials on matters they might be wary of speaking candidly about in public view. The permitted uses of executive sessions are defined in the Georgia Code. They include discussions involving matters covered by attorney-client privilege, like lawsuits or settlements. Notably, they include discussions about employment matters, like whether to hire or fire people. They also include discussions about acquisition or disposal of property and real estate and investments of public retirement systems. Executive sessions also protect meetings where the agency is considering or discussing portions of a record exempt under the ORA, and there is no way for the agency to consider this record without disclosing the exempt portions of it. To give an example, say a school board has been receiving complaints about a principal at a local middle school, and the board is considering firing him. The board meets, but after lengthy debate, they decide to keep the principal in his position. Now imagine if these employment matters were fully open to the public, where board members were airing personal grievances about the principal in front of the entire community. And in the alternative, some may be unwilling to speak about personal or sensitive information of the principal for fear of damaging his reputation, even if this information would be critical in the decision-making process. This example highlights the purpose of executive sessions, to allow for certain information to stay confidential in these limited circumstances to allow for more efficient governance. It's also important to note that an agency cannot simply call an executive session for whatever they want. The Georgia Code provides various requirements in order to legitimately call an executive session. The agency must enter the specific reasons for the closure into its official minutes. It must be closed by a majority vote of the quorum present for the meeting. The minutes shall reflect the names of the members present at the meeting and the names of those voting for the closure. And this list must then be made available to the public. Minutes of the meeting will be recorded, although not available to the public. And if only part of the meeting is covered by an exemption, then the other portion of the meeting not subject to the exemption must be open to the public. And the minutes of such portions not exempt must be taken, recorded, and open to public inspection as any other meeting subject to the OMA would be. If my city is live streaming technology, is the city council required to broadcast those meetings live? The short answer is no. Under the OMA, the city council meetings are simply required to be open to the public, meaning the public has contemporaneous access to observe the meeting as it's occurring. While many city councils across Georgia offer public access via Zoom or live streaming of meetings in this post-COVID or current COVID world, there's no requirement under the OMA for them to do so, so long as the meetings are open to the public through another channel, like in-person attendance or dial-in audio access. But perhaps it's also worth noting that if, say, your city has invested large sums of money into live stream technology and they're not utilizing it, you do have a First Amendment right to petition the government to use this technology that your tax dollars went to fund. But all that to say, the OMA provides no requirement to have live stream available, as long as the citizens can access the meeting through another channel. Can I be kicked out of a government meeting? No, not unless you're disrupting the meeting. The OMA's stated purpose is to protect the public from closed-door politics and the potential abuse of individuals and the misuse of power such policies entail. And it calls for the act to be broadly construed to uphold these interests. Thus, there's a broad notion of openness that would prevent removal of individuals from meetings. However, there's also this other significant government interest in conducting orderly, efficient meetings of public bodies. So people can be removed from a meeting if removal is in the interest of public order and to allow for the proper functioning of the meeting. Examples of disruptive behavior that might warrant removal would include, for example, repeatedly speaking outside of a public comment period, repeatedly interrupting or speaking or shouting over others, engaging in physically threatening conduct towards other attendees, or otherwise preventing the meeting from being able to proceed. However, any removal must be narrowly tailored to accomplish the government's interest in continuing the meeting. Notably, making a video or sound recording of a public meeting is explicitly authorized by the OMA and does not, standing alone, provide a basis for removing someone from the meeting. Finally, it's important to note that a Georgia law that made disruption of public meetings illegal was found unconstitutional for being overly broad. However, other charges like disorderly conduct could be brought where a member of the public disrupted a meeting, and this application of the law has not been found unconstitutional. So you have these two government interests that the government must weigh to warrant any removal from a public meeting: the OMA's principles of openness and the agency's need to conduct their meetings efficiently. And next we have this question about advisory committees. For example, if my city's mayor has formed an anti-violence advisory group, are the group's meetings required to be open to the public? Atlanta Journal v. Hill, which was decided in 1987, was the controlling case here, finding that an advisory committee created by a mayor was not subject to the same OMA requirements as committees that actually make governing decisions. But the statute that Atlanta Journal relied on was amended in 2012 to broaden the language describing what kinds of meetings must be open. The language of the statute at the time Atlanta Journal was decided was any agency at which proposed official action is to be discussed or at which official action is to be taken. The amendments broadened the language beyond just official action and added any committee created by the governing body at which any official business, policy, or public matter of the committee is formulated, presented, discussed, or voted upon. So the short answer is probably yes. While we don't have a case that directly applies to this changed language, it seems on its face that the broad revised language of the OMA would or could encompass an advisory committee meeting application of the OMA. So now that I've covered some of the basics, so now that Kyle and I have both covered some of the basics of the ORA and the OMA, I'm going to turn it over to my colleague, Austin Albertson, to discuss some practical applications of Georgia Sunshine Laws to yourselves and your communities. Thank you.
Hello, my name is Austin Albertson, and I'm a third-year law student at the University of Georgia School of Law, working in the First Amendment Clinic. So now that we've heard about the Open Records Act, the Open Meetings Act from Paige and Kyle, I want to talk about some of the more direct interactions that these laws have with your local government and the officials and with you. So what about the people who directly serve you? You've probably got some questions about how local officials interact with you and the types of transparency that you can expect out of your local government. The short of it is your local government works for you. The Open Records Act reaffirms this and gives you access to most of the information used by your local officials. By using the Open Records Act, you can stay informed about day-to-day operations and the goings on in your community in more ways than you might think. So can we find out about how much our local officials get paid? Absolutely. Your local government officials are paid salaries that are funded by taxpayer dollars and are subject to disclosure. The Open Records Act allows disclosure of governmental records, including personnel records that include salary. Public employees, those being employees of your county or municipality or its agencies, are the types of personnel whose salary information is subject to disclosure under the Open Records Act. So what about online? Can my elected official block me on Facebook? Well, the answer is it depends. More completely, the answer is that it depends on how the official uses their page. If they use their page to talk with and engage with constituents and the public about their official duties and public works, they can't block you from being able to view or comment on the page based on disagreement or general dislike with comments you've posted. By blocking you from expressing your own opinion and thereby preventing you from speaking further on the page or from receiving the speech of others who post or comment on that official would violate your First Amendment rights. However, if the official created and uses the page in their personal capacity for their personal communication and not in their official capacity, then they're free to block you from their page. This line between personal and official is really blurry, and courts use a variety of factors to try and separate official and personal pages, including who has access to the page, including whether the general public does, whether the page promotes official events or informs the public of activities related to the official's office, whether the page is used to talk to constituents directly, whether the page includes markers of any official status, like the official's title or photos of the official doing any official conduct, and how it is regarded and treated by both other government officials and by members of the general public. You should note, however, that campaign and election pages are generally considered under First Amendment law to be private, even if the candidate already holds public office. So it's much harder to argue that your First Amendment rights have been violated if you're blocked from a campaign or election social media page. This also extends to political party pages like the Georgia Democratic Party or Republican Party, as they are private groups. So what about keeping up with your community's most recent developments in real estate and planning? Knowing how your community is growing and expanding, as well as any big projects coming to your neighborhood, can help keep you engaged with the place that you call home. It allows for neighborhood planning and active participation in how your community will grow. And using the Open Records Act, you can get access to many land records. Real estate deeds, zoning maps, and other records related to land are all available through the ORA and may already be publicly available to you online. Even if your county doesn't have an online index, these records are still available through your county clerk's office. Economic development projects and private entities doing public work for any government agency are also subject to disclosure under the ORA. Additionally, under the Open Meetings Act, all of your county zoning boards, planning commissions, and regional development authorities have to make their meetings open to the public. So watch for any meeting notices, agendas, and minutes that are posted for public view. So how about crime records so that I can track problems in my community? Many police records are available under the Open Records Act. This includes incident reports and arrest reports, even those while investigations or prosecution are still pending. These records can be obtained from your local law enforcement, county law enforcement, and even state law agencies. And plenty of resources online also allow you to track crime in your community. The Georgia First Amendment Foundation provides an excellent resource on their website called the Blue Book that gives details on obtaining all kinds of law enforcement records. Additionally, the Georgia Department of Corrections maintains records of all currently and previously incarcerated offenders on their website, and the Georgia State Sex Offender Registry is also available online at the Georgia Board of Investigations website. So what about me? What about the Open Records Act and how it pertains directly to you? What records of yours can be obtained? Are my tax records public? No, the Open Records Act has an exemption for tax information and records under OCGA 48760. Is my voting record public? Not necessarily. Some of your information is available through the Georgia Secretary of State's office, like your address, race, gender, and the last time you voted, and if you're registered with the Democratic or Republican Party or as a nonpartisan, which could indicate who you intend to vote for in the general election. But who you actually vote for is completely private, which leads us to, what about cast ballots? Georgia has a new voting law, SB 202, passed in March of this year. In this law, a pilot program was established to test the release of cast ballots to the public. And earlier this year, in May, a Fulton County court granted an open records request for ballots cast in Fulton County. However, as mentioned before, these records are still subject to the disclosure restrictions to prevent any personal identifying information from appearing anywhere on the ballot. The scanned ballots that are released will only include votes cast, none of your personally identifying information. And finally, is my open records request a public record? Yes, it is. This concludes the PowerPoint presentation of the Open Records Act and the Open Meetings Act and how it interacts with you in the community. We appreciate you listening to our presentation, and we're now going to open the presentation up to any general questions you may have, and we're happy to do our best to give you an answer. Any questions we don't have a direct answer to, we'll be happy to research and get back to you with an answer. Thank you.
So thank you to Paige, Kyle, and Austin for that really helpful overview of the Open Records Act and the Open Meetings Act, and also other issues of open government and social media by public officials. So now we are in the section of our presentation where we will try to answer your audience questions, and we already have a number of questions in the Q&A. So I will just start at the top and put the questions out to our panelists. And if none of them feel comfortable answering, I will offer my advisory opinion subject to possibly clarification if it's a question that we can't answer on the spot. So let's start with a question about a school board meeting. So if the school board meeting is live streamed, are they required to live stream the meeting in its entirety minus any executive sessions? Or can they live stream the meeting but choose not to live stream public participation like public comment? Do our panelists have any thoughts on that question? No takers?
So I would think that the answer to this question would begin with public comments. And as Paige stated, you know, the Open Meetings Act does not require agencies to provide for public comment periods. And so our clinic has argued that, you know, and sort of touching on some of the other questions that have been asked, but our clinic has argued that in the age of COVID, when it's, you know, not necessarily safe to attend meetings in person, that live streaming meetings is the best way to comply with the spirit of the Open Meetings Act and its commitment to transparency and accountability, although live streaming is not necessarily required. And so my hunch would be that live streaming the public comment period would not necessarily be required unless the public comment period was being shut off in a retaliatory fashion in order to, you know, shut off other people from hearing a certain kind of viewpoint of speech that's being expressed during that public comment period.
So I think to Sam's point, live streaming is not required if the meeting is open for in-person attendance. So if people could come in person and see and observe the whole meeting, including public comment, I think the city or the school board might have an argument that they could, selectively live stream parts of the meeting. But I think it would be incumbent upon them to announce that ahead of time, which parts they were not going to live stream, so that people who did want to observe the whole meeting could, come in person. So great question. And those are our best informed thoughts at the moment on how we would answer that. So next question is about COVID-19, when there is a concern about socially distancing if you attend a meeting in person, and what if not all the individuals who want to attend a meeting are allowed in because of the social distancing requirements? What is the school board or city required to do for that meeting to make sure that it's open to all? Does anyone have any thoughts on that?
Yeah, if no one else got that, my understanding of the OMA would be for that one, general access is probably enough, as long as it's opened up to the general public. And if seating requirement doesn't accompany everyone, I think the general requirement of the OMA would be that it just has to be open to the public. That's my general understanding.
I think that's right, that if it's open for in-person attendance and it so happens that not everyone can fit in the room, the entity is still technically in compliance with the letter of the law. We have argued in the past that it's not in compliance with the spirit of the law, however, that if more people want to attend than can fit or safely fit into the room that you've scheduled that meeting to be held in, you need to make overflow accommodations by having the meeting videoed and shown in an overflow room where people can see on the screen what's happening, or providing other options for access like dial-in or live stream, if you reasonably anticipate that not everybody is going to be able to physically fit into the room. So that would be our recommendation, to uphold the spirit of the OMA. The letter of the OMA does not require that, however. Okay, so next question. It says, extensive conversations regarding COVID-19 within the school system have allegedly taken place during staff meetings. Are these meetings of the staff of the school systems open to the public? And are meetings required, or are minutes required from those staff meetings? Anyone want to take a stab at that one? Okay, so I want to refer back to the definition of a meeting, which is defined as the gathering of a quorum of the members of the governing body of an agency. So I don't think that a staff meeting would meet that definition because it's not the governing body. And so staff meetings would typically not be considered open meetings that people have a right to come and observe. And there would be no requirement for minutes of those meetings to be publicly available or even kept at all. That would be up to the school or the entity to decide if they would have minutes from their staff meetings. Okay, so going on to, we have a lot of questions about open meetings. All right. So does a discussion of employee raises in general, like an annual cost of living increase for all employees or pay increases for an entire department, qualify for an executive session? Or is it only like individual raise discussions that would qualify for an executive session? Any thoughts on that? So I think this is a question that is really open to interpretation. So the Open Meetings Act does say that discussions about employment, including compensation, are appropriate for an executive session. It also has another clause that says that general policies of that agency, discussion of general policies would not be appropriate for executive session. So I think you could very well get into a debate over whether an across the board cost of living raise would be considered a policy, or would that be considered a discussion about compensation. And I could see good arguments on both sides of that debate. So I'm going to leave it at that. All right. So going on, it says, if the cost for an open records request response seems very high, say, for example, over $1,000 for 3 weeks worth of emails that only results in about 200 emails, would this be cause for concern? Is this acceptable? And what can be done not to have cost be a deterrent for obtaining records?
I can take this one. So the Open Records Act calculates the amount spent to produce records based on the wage of the person, of the employee doing that search. And so without any further information, and assuming that collecting these emails was done by, typing some search terms in a search box in someone's email account, my hunch would be $1,000 for something that probably took maybe 20 minutes seems a bit high. And so the first thing that I would recommend would be to send a letter or even, just an email asking why, asking them to explain how they arrived at that number, and then pointing them to the relevant provision of the Open Records Act saying that the amount that they should pay should be, consonant with what the employee that conducted that work would be paid for the time that they spent doing that search.
So one thing that you can do when making open records requests is to ask in advance that the anticipated cost be relayed to you so that you can decide whether or not you want to agree to pay it. I would suggest doing that just to make sure that you don't wind up being on the hook for an expensive open records request that you actually, it's not worth it to you to pay the money. I will say that for reviewing or producing something like emails, depending on the subject matter, there might have to be some attorney review of the emails. For instance, if there was going to be an issue of attorney-client privilege that had to be screened for. So I could see how you might only wind up with 200 emails, but the work entailed in finding those emails, having an attorney review them for privilege, and then producing them could rack up some expense. Sam may have already mentioned that, but under the ORA, the agency is required to have the lowest paid full-time employee who is capable of conducting the search do the search. So, they shouldn't be paying an attorney to do the search, but they might have to pay the attorney to do the review. So again, I think as Sam mentioned, pushing back on the amount of the cost and pointing out to the agency, hey, you have to have the lowest paid full-time employee who can do this, be the one to do it. And to ask even, for the hourly rate of the employee who did it, or at least a breakdown of the cost so you can understand where it's coming from. I think that's all reasonable to ask for. And you can ask for that ahead of time so that you can then either decide you want to go forward with the request or maybe modify it. So let's see what else we have. It says the school system's social media page restricts comments on their pages if the topic concerns something that could receive comments of varying opinions. Is that legal? Any thoughts from our panelists?
Generally, restricting comments or limiting someone's ability to comment on a public forum like that, if it's used to broadcast news of the school district, is generally frowned upon. And so my gut feeling on the spirit of the law would be that restricting comments, generally you should err on the side of caution and not restricting comments on the page.
I think that's right. I mean, where a school or other public agency has opened up their social media account for general discussion. You know, they haven't put like specific topic limits on what can be discussed. They aren't allowed to restrict people's speech on the basis of their viewpoint. And so if they are trying to, for instance, avoid debate over a controversial issue, and they're trying to maybe only selectively have certain views on that issue show up on their social media page, that could potentially be a First Amendment violation. That being said, public agencies do have the right to create what's called a limited forum on their page, where they specify these are the topics that can be discussed here. And if you stray outside of those designated topics, then, you know, they could delete your comment or potentially block you if you did that repeatedly, because they do have the right to control sort of what the forum is open to discuss. But on any particular topic, they cannot restrict the views that are expressed on that topic. Okay, so going on, it says, if a zoning board provides a live streaming link to members to participate in the meeting, are they also required to provide that link to the public, or is just being open to the public for physical attendance enough? Any thoughts on that?
So yeah, under the Open Meetings Act, Paige talked about this a little bit, but it's the law is the contemporaneous access. So public is probably enough if they allow physical attendance to the general public. They don't have to provide every means of participating as long as they provide a means generally.
Yes, I think that's correct. And as far as like the members of the governing body attending via live stream, the OMA provides that they can do that if they need to for extenuating circumstances, for health reasons, but they're only allowed to do that, I think it's twice in a 1-year period, unless they have like a medical note from their health providers saying that they need to be able to attend remotely. But generally, if a meeting is open to physical attendance to the public, that's all that's required, even if members of the governing body are zooming in. Okay, so next question. How would you deal with an agency claiming that redaction of the data is creating new data and therefore denies your request?
I can jump in here. I think so. The ORA makes it clear that search, retrieval, and redaction is part of any records request. It's something that they'll have to do when records are accessible. So if they've denied, it may require a little back and forth, maybe explaining like, hey, you guys can tailor it a little and you can redact a little. And if you keep getting denied, it may end up being a letter. But redaction is not necessarily broad, and without details for this question, redaction is not out of the like realm of possibility, I believe.
Yes, so they could redact the data, and that doesn't, I don't understand the argument about that somehow creates new data. If part of the data falls within an exemption of the Open Records Act or some other law that allows for privacy protections and therefore things have to be redacted, that's fine. But the responding agency has to identify the basis for the redactions. But I don't think they can deny the whole request just because part of it has to be redacted. Okay. So we have a comment here that says, one note about tax records, property tax records are public records. Federal and state tax returns are private. So yes, thank you for that clarification. Next question is, what's the best recourse for a reporter denied access to a public meeting or anyone denied access to public records?
I can jump in here, and I mean, I'll say generally first, and then we can get into the specifics of the law. But this question comes to comment that says like often the individual is not like a high level official or policymaker, which is why it's always good when you make any sort of requests or you're dealing with people to just go in with a good attitude. These are people that if you go back and forth to make requests multiple times, you're going to need to establish like a rapport with and a good relationship with. And so I guess this is just like a general advice to just go in and you're fostering a relationship, honestly, a lot of the time. And maybe it's not best, like I said, maybe establish a back and forth. Don't go aggressive with the legal letter right away. But sometimes you will have to go and just ask explanations, see what's up, assess, and then form a relationship with the custodian of the records or whoever's in charge.
So I think that's a very good answer on the public records issue, that you want to first try the nice way and see how far you can get with that. And if not, maybe do a written letter sort of appealing the denial, explaining why you think the denial was not justified. In terms of being denied access to a public meeting, again, to prevent it from happening in the future, if you have relationships with other members of that governing body, you may want to raise it with them and see if you can obtain some assurance that that won't be repeated. However, both the Open Records Act and the Open Meetings Act do allow for enforcement through court actions brought in Superior Court, and any person who has been denied access to a meeting or been denied a public record that they believe the law entitles them to has a right to file a lawsuit, essentially, to get the court's ruling on that. Regarding minutes, do only items voted on by the agency need to be included in the minutes? For example, if the agency did not vote on a mask mandate, it was just announced at the meeting, can that be excluded from the minutes? Any thoughts on that one?
I can also, and then someone can correct me. If there's been a motion or a proposal about a mask mandate, I think that that's within the minimum requirements for an executive session. So if there's been like an official motion, I think maybe that should be in there, even if a vote hasn't been taken, but someone can correct me on that if I'm wrong.
So according to the OMA, in terms of minutes from the open part of the meeting, the only things that the OMA require the minutes to include are the names of the members of the governing body who are present at the meeting, a description of each motion or other proposal made, the identity of the persons making and seconding the motion or other proposal, and a record of all votes. So if there was simply an announcement made at the meeting that there was or was not going to be a mask mandate, technically that would not have to go into the minutes according to the letter of the OMA. Now, presumably there would have been some other meeting where that was voted on and decided that should have been open, and there should be minutes from that other meeting. And keep in mind that meetings can be virtual and electronic as well as in person. So if you have a quorum of the governing body getting together at a designated time to have a phone call or to have a text message conversation, that can constitute a meeting for purposes of the Open Meeting Act, and should be open and should have minutes. And decisions taken at meetings that were not open when they should have been can be challenged as void. However, that challenge has to be brought within a pretty close period of time after the non-compliant meeting. So usually within 90 days of when that meeting took place. Okay, next question. Are we responsible for attorney fees incurred by the agency as a result of the request? Any thoughts on that? So I think in the example we talked about earlier, where you have a seemingly very high charge for, response to an Open Records Act request, it's possible that could include some attorney's fees if you have to have attorney review to produce the records. In terms of other ways in which attorneys might be involved, if it's not directly related to actually producing the records, I would think that that could be challenged. Like if the agency is just calling their attorney to say, do we have to comply with this? They can't charge you for that, but they could charge you if the attorney has to be the one to collect the records for some reason, or do review for purposes of redaction, that kind of thing. Okay, so our last question in the Q&A says, so Atlanta City Hall has been closed since the beginning of COVID. It may have just reopened. Is this legal? If so, is that because they allow access via email and or phone? Any thoughts there? So I'm assuming this question means like public meetings in Atlanta City Hall have been closed for in-person attendance. If they are providing other access like dial-in or live streaming, then that would still comply with the Open Meetings Act. Okay, well, that brings us to the end. We have one more comment. That any work product from a school staff meeting would be a public record, such as agendas, minutes, if taken, exhibits, etc. So that's a good clarification. So the staff meeting would not be an open meeting necessarily, but it could result in the generation of public records that would be obtainable through the ORA. So thank you for that clarification. So that brings us to the end of our questions and conveniently almost the end of our hour. So I'm going to turn it back over to Sam to close us out.
Thank you so much, everyone, for attending today's citizen training on open government in Georgia. We hope that after this training, you feel more knowledgeable about Georgia's Open Records Act and Open Meetings Act, as well as the ways that they can be used to demand accountability from your local and state officials. We appreciate everyone's participation, a lot of questions. If your question wasn't answered today, please feel free to submit an inquiry to the UGA First Amendment Clinic website or to the Georgia First Amendment Foundation website. And be on the lookout for a written resource containing all of the information covered in today's presentation that will be emailed to the address you used to register for today's webinar. So that's it. We look forward to seeing you all again soon. Take care.